This is the online law class, and we left off at the grand jury information, and we'll go over and cover some grand jury case law here. It's document 18 in class docs, and so the first case, United States versus Williams, was a really important case because it basically reaffirmed that the grand jury is the fourth branch of government, and that its authority emanates from the Bill of Rights, so there's basically nothing they can do about it. So, as it says, the power of the grand jury, in a 6-3 decision, Scalia, writing for the majority, confirmed that the American grand jury is neither a part of the judicial, executive, nor legislative branches of government, but instead belongs to the people. It is, in effect, a fourth branch of government, governed and administered to directly by and on behalf of the American people, and its authority emanates from the Bill of Rights. So, whenever the people decide to get together and do something as far as grand jury is concerned, there's nothing that they can do to say one thing about it one way or the other. So the power remains in the people, as it always has. And that's the aspect of a grand jury and the importance of it. As Blackstone describes the prevailing practice in 18th century England, the grand jury was, quote, only to hear evidence on behalf of the prosecution for the finding of an indictment, is only in the nature of an inquiry or accusation, which is afterwards to be tried and determined. But remember the aspect of the prosecution can be private, okay? It doesn't have to be public. And there's no rules on how the grand jury shall proceed. Given the grand jury's operational separateness from its constituting court, it should come as no surprise that we have been reluctant to invoke the judicial supervisory power as a basis for prescribing modes of grand jury procedure. So what they're saying is that we can't tell you guys what to do because you're above us. They couldn't, even if they wanted to. So when they say reluctant, that's attorney speak for we can't. Okay. Over the years, we have received many requests to exercise supervision over the grand jury's evidence-taking process, but we have refused them all. Well, it's because they can't accept any of them, including some more appealing than the one presented today in Calendra versus United States Supra. A grand jury witness faced questions that were allegedly based upon physical evidence the government had obtained through a violation of the Fourth Amendment. We rejected the proposal that the exclusionary rule be extended to grand jury proceedings because of the, quote, potential injury to the historic role and function of the grand jury. So what that's saying is if somebody, whoever, goes and attains some information that would be in violation of someone's Fourth Amendment rights, you can still bring that for a grand jury. So however you can get it, however it can be found, however it can be obtained, as long as it gets in front of the grand jury, it can be valid from the standpoint of bringing an indictment, okay? Which is pretty powerful, so you can just basically bypass the Fourth Amendment. We declined to enforce the hearsay rule in grand jury proceedings since that would, quote, would run counter to the whole history of the grand jury institution in which laymen conduct their inquiries unfettered by technical rules. So, again, grand jury is above the law. Grand jury is the law. Okay. No doubt, in view of the grand jury proceeding status as other than a constituent element of a, quote, criminal prosecution, we have said that certain constitutional protections afforded defendants in criminal proceedings have no application before that body. The double jeopardy clause of the Fifth Amendment does not bar a grand jury from returning an indictment when a prior grand jury has refused to do so. We have twice suggested, though not held, that the Sixth Amendment right to counsel does not attach when an individual is summoned to appear before a grand jury, even if he is the subject of the investigation. So, you want to subpoena somebody in front of the grand jury, and they're the ones that are going to read an indictment? Sixth Amendment can't protect them. Ask them any questions you want to. If they don't answer, hold them in contempt. Pretty simple. And although the grand jury may not enforce a witness to answer questions in violation of the Fifth Amendment, constitutional guarantee against self-incrimination. So it says you can't force them, but at the same time, they basically would just sit there and not say anything. Well, if it's a document, say, that you're demanding documents from them, and even if it may be self-incriminating, you can still hold them in contempt, which is what we'll get into as far as Hale versus Hinkle is concerned. Our cases suggest that an indictment obtained through the use of evidence previously obtained in violation of a privilege against self-incrimination is nevertheless valid. So if you can get it out of them, you can get it out of them. Judges have no effect on the grand jury but to call them and administer their oath. Judges have no effect on the grand jury but to call them and administer their oath. Although the grand jury normally operates, of course, in the courthouse and under judicial auspices, its institutional relationship with the judicial branch has traditionally been, so to speak, at arm's length. Judges' direct involvement in the functioning of the grand jury has generally been confined to the constructive one of calling the grand jurors together and administering their oaths of office. That's it. That's all they do. After that, grand jury is in full power. a private prosecutor can bring a presentment to the grand jury. Under the ancient English system, criminal prosecutions were instituted at the suit of private prosecutors, to which the king lent his name in the interest of the public peace and good order of the society. In such cases, the usual practice was to prepare the proposed indictment and to lay it before the grand jury for their consideration. There was much propriety in this, as the most valuable function of the grand jury was not only to examine into the commission of crimes, but to stand between the prosecutor and the accused, and to determine whether the charge was founded upon credible testimony or was dictated by malice or personal ill will. That's Hale versus Hinkle. Okay, and of course, corporations have no Fifth Amendment immunity at all. Officers of a corporation cannot deny the production of the corporation's books based on the Fifth Amendment. The grand jury can take presentment from private prosecutors. The grand jury can investigate any crime they suspect has happened on witness testimony. Now we get into Hale versus Hinkle. And the whole rest of this, the reason why it's 24 pages, is because I put in to this doc the entire case, because this case has never been overturned, and it's extremely important to understand the powers of the grand juries. As I made a note here, use this to collect all books in the county, and all the books on the courts, and all the books on all securities created by the courts. And all we need is a DUNS number, and they're fucked. So that's it, because they're operating in commerce. So they're a corporation. Gimme. Right? So you could go into, a grand jury could go in and demand the production of all the books of a court and say, looks like you guys are creating an awful lot of bond money here. Where's all that going? 501c3 slush funds for judges' retirements? Where's it going? Demand to produce the books. Anyway, I'm not going to read all of Hale versus Hinkle. I'll just skip down to some various different parts here. The benefit of the Fifth Amendment are exclusively for a witness compelled to testify against himself in a criminal case, and he cannot set up on behalf of another person or individual or of a corporation of which he is an officer or employee. So, an officer or an employee that doesn't want to give up the books for whatever reason can be held in contempt of the grand jury. Okay? He cannot set it up against the production of books and papers, as the same statute would generally grant him immunity in respect to matters provided thereby. The search and seizure clause of the Fourth Amendment was not intended to interfere with the power of the courts to compel the production upon a trial of documentary evidence through a subpoena. Okay, so the grand jury can do their own subpoenas. While an individual may lawfully refuse to answer incriminating questions, unless protected by an immunity statute, a corporation is a creature of the state. And there is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. So, because it's a creature of the state, it's a chartered thing. All the powers inherent in the people? Okay, we don't like you. Do you think we're doing something wrong? Investigate them, indict them, and pull their charter. You revoke a corporation's charter, that is the end of that corporation. I don't care what corporation it is. I don't care if it's Monsanto. Okay? You get rid of their charter, you get rid of them permanently, forever, done. There is a clear distinction between an individual and a corporation, and the latter, being a creature of the state, has not the constitutional right to refuse to submit its books and papers for an examination at the suit of the state, and an officer of a corporation which is charged with criminal violation of statute cannot plead the criminality of the corporation as a refusal to produce its books. So basically what happened, and I'll read some more here too, but the gist of Hale versus Hinkle was this, that there was a guy who was subpoenaed to produce the books of a corporation. He refused. Grand jury held him in contempt, put him in jail, said produce it or we'll just keep you there. Well, he sued out a writ of habeas corpus. Well, the writ of habeas corpus came before a judge, and the judge said, what do you want me to do? You are being held in contempt of the grand jury. I can't do anything. And that was the point. So, you can't get out if the grand jury is holding you in contempt. So you want real power? There it is. Okay. So a corporation is but an association of individuals with a distinct name and legal entity. And in organizing itself as a collective body, it waives no appropriate constitutional immunities. And although it cannot refuse to produce its books and papers, it is entitled to immunity under the Fourth Amendment against unreasonable search and seizures. And where an examination of its books is not authorized by an act of Congress, a subpoena requiring the production of practically all its books and papers is as indefensible as a search warrant would be if couched in similar terms, meaning it has absolute power. Although a subpoena may be too broad in its requisition, where the witness has refused to answer any question in order to produce any books or papers, this objection would not go to the validity of the order committing him for contempt. So, point is, if they refuse to give up the books, you can hold them in contempt. This was an appeal from a final order from a circuit court made in 1905, dismissing a writ of habeas corpus and remanding the petitioner Hale to the custody of the marshal. The proceeding originated in a subpoena in 1905, commanding Hale to appear before the grand jury at a time and place named to testify and give evidence in a certain action now pending in the Circuit Court of the United States of the Southern District of New York between the United States of America and the American Tobacco Company and McAndrews and Forbes Company on the part of the United States that you bring with you and produce at the time and place aforesaid. 1. All understandings, agreements, arrangements, or contracts, whether evidenced by correspondence, memoranda, formal agreements, or other writings between McAndrews and Forbes Company and 6 other firms and corporations named from the date of the organization and of the said McAndrews and Forbes Company. All correspondence by letter or telegram between McAndrews and Forbes Company and other 6 firms and corporations. All reports made or accounts rendered by these 6 companies and all companies or corporations to the principal company. You see how extensive this is getting. Any agreements or contracts or arrangements, however evidenced between McAndrews and Forbes Company and the Amsterdam Supply Company or the American Tobacco Company or the Continental Company or the Consolidated Tobacco Company. So again, this is just getting broader and broader and broader as far as what they wanted. They wanted everything. All letters received by the McAndrews and Forbes Company since the date of its organization from 13 other companies named, located in different parts of the United States, and also copies of all correspondence with such companies. That's just crazy, but that's what they wanted. Petitioner appeared before the grand jury in obedience to the subpoena and, before being sworn, asked to be advised of the nature of the investigation in which he had been summoned, whether under any statute of the United States, and the specific charge, if any, had been made, in order that he might learn whether or not the grand jury had any lawful right to make the inquiry, and also that he be furnished with a copy of the complaint, information, or proposed indictment upon which they were acting, that he had been informed that there was no action pending in the circuit court, as stated in the subpoena, and that the grand jury was investigating no specific charge against anyone, and he therefore declined to answer. See? He just thought because, well, if you don't have anything to go against, you don't have the right to do that. Well, the hell they don't. And he therefore, and first, because there was no legal warrant for his examination, and second, because his answers might tend to incriminate him. Whereupon, the grand jury reported the matter to the court and made a presentment that Hale was in contempt and that the proper proceedings should be taken. Thereupon, all the parties appeared before the circuit judge, who directed the witness to answer the questions and produce the papers. Appellant still persisting in his refusal, the circuit court held him to be in contempt and committed him to the custody of the marshal until he should answer the questions and produce the papers. A writ of habeas corpus was thereupon sued out, and a hearing had before another judge of the same court, who discharged the writ and remanded the petitioner. Mr. Justice Brown delivered the opinion of the court. 2 issues are presented by the record of this case, which are so far distinct as to require separate consideration. They depend upon the applicability of different provisions of the Constitution and in determining the question of affirmance or reversal should not be confounded. The first of these involves the immunity of the witness from oral examination. The second, the legality of his action in refusing to produce the documents called for by the subpoena. The appellant justifies his action in refusing to answer the questions propounded him, first upon the grounds that there was no specific charge pending before the grand jury against any particular person, and 2, that the answers would tend to incriminate him. The first objection requires the definition of the word charge as used in this connection, which it is not easy to furnish. An accused person is usually charged with a crime by a complaint made before a committing magistrate, which has fully performed its office when the party is committed or held to bail. That's on a warrant of commitment. And is quite unnecessary to the finding of an indictment by a grand jury, or by an information of the district attorney, which is of no legal value in prosecutions for felony, or by a presentment usually made, as in this case, for an offense committed in the presence of the jury, or by an indictment by which, as often as not, is drawn after the grand jury has acted upon the testimony. If another kind of charge be contemplated, when and by whom must it be preferred? Must it be in writing? And if so, in what form? May it be oral? The suggestion of the witness that he should be furnished with a copy of such charge, if applicable to him, is applicable to other witnesses summoned before a grand jury. Indeed, it is a novelty in criminal procedure with which we are wholly unacquainted, and one which might involve a betrayal of the secrets of the grand jury room. So he was basically looking around to see, well, why do I have to answer? And the judge came back and said, because they told you to. Okay? So, under the ancient English system, criminal prosecutions were instituted at the suit of private prosecutors, to which the king lent his name and so on and so forth, which I've already read. We are pointed to no case, however, holding that a grand jury cannot proceed without the formality of a written charge. Indeed, the oath administered to the foreman, which has come down to us from ancient times, is found in Rex v. Shaftesbury, indicates that the grand jury was competent to act solely on its own volition. This oath was, quote, "You shall diligently inquire and true presentments make of all such matters, articles, and things as shall be given you in charge, as of all other matters and things as shall come to your knowledge touching this present service." This oath has remained substantially unchanged to the present day. There was a difference, too, in the nomenclature of the two cases of accusations by private persons and upon their own knowledge. In the former case, the action was embodied in an indictment formally laid before them for their consideration. In the latter, in the form of a presentment, Blackstone says, a presentment, properly speaking, is a notice taken by a grand jury of any offense from their own knowledge or observation, without a bill of indictment laid before them at the suit of the king, and the presentment of a nuisance, libel, or the like, upon which the officer of the court afterwards frame an indictment before the party presented can be put to answer it. So there's the point right there, that they have to answer what they've been demanded. Okay, so I'm not going to read the rest of this. Hale versus Hinkle is clearly a very long case, but the little red part here: if a grand jury of their own knowledge or the knowledge of any of them, or from the examination of witness, know of any offense committed in the county for which no indictment is preferred to them, it is a duty either to inform the officer who prosecutes for the state of the nature of the offense and desire that an indictment for it be laid before them, or, if they do not, or if no such indictment be given them, it is their duty to give such information of it to the court, stating, without any particular form, the facts and circumstances which constitute the offense. This is called a presentment. So, grand juries think something's going wrong? They want to investigate? They don't have to have a reason. Even on the suspicion that there might be something going on that has any aspect of illegality, they can go after. Okay? So that's the point of the grand juries. And I'll leave the rest of the Hale versus Hinkle if anybody wants to read it. You can read it at your own volition. But that's the point. So, from grand jury case law, we can move on now to the aspects of the requirements of any case. Okay? So, facts, evidence, and law. Now, this is where we're getting into what you have to have when you prosecute a case. So it doesn't matter what it is, whether it's a civil matter and, your neighbor's tree landed on your garage, or whether it's trespass, his cow got out and trampled all over your lawn and ate your flowers or whatever. Or even if it's a criminal matter, wherein we saw in Hale versus Hinkle, anything that the grand jury feels is wrong, or anything that you feel as one of the people to file an action at law in a court of record, to bring the main things. Always remember these three things. You got to have your facts, your evidence, and your law. Okay. So let's bring up number 19, facts, evidence, and law. And again, this is from Bouvier's. So a fact, an action, a thing done. It is either simple or compound. A fact is simple when it expresses a purely material act unconnected with any moral qualifications. For example, say Peter went into his house. It is an express and simple fact. A compound fact contains the materiality of the act and the qualification which that act has in its connection with the morals and the law. To say that Peter has stolen a horse is to express a compound fact. For the fact of stealing expresses at the same time the material fact of taking the horse and of taking with him the guilty intention of depriving the owner of his property and appropriating it to his own use, which is a violation of the law of property. So you have facts. So you put down your facts in your case. Now, in going through and understanding facts, evidence, and law, let's, at the same time here, as we're kind of looking at these definitions, let's bring something else up so we can kind of jump back and forth here, which is the court of record. Let's open up the court of record template, number 21, and take a look at the court of record template, and you'll see I have things color coded. So the template is basis of everything that's in red you need to change to fit your case. Remove everything in purple because that's just notes of mine, and then leave what is in blue, but change the font to black color before printing it. And this is basically an open template, okay, for an action at law. So you'd name the action or the claim here, whatever it was. So say action of trespass on the case, action of account, whatever it may be, and you'd pick your common law action. verified and tested and sealed. That's all the boilerplate stuff at the bottom. And so now we get into how you do an action at law. So your action at law, so your declaration. So in an action at law, you have a declaration. In equity, you have a complaint. In military jurisdiction, you have a court-martial. And in ecclesiastical court, you have an accusation. So those are the various different things that correspond to each different jurisdiction of law. So in an action at law, you have a declaration. So the declaration starts with the first paragraph is what you're doing. So it comes now, John Henry, House of Doe, who is at all time mentioned in the following declarations, action at law, a people of Illinois, having been found to be living, have come of full age, competent to give testimony stated herein, hereinafter plaintiff. And in this court of record, there's your common law court, hereinafter superior court, sues whoever, herein defendant, in an action of trespass and whatever the action is, and demands the answer plaintiff in the following actions to it. So, plaintiff sues defendant and alleges. Introduction. Now, this is a short synopsis of the suit in general. Now, the reason why I wanted everybody to bring this up and take a look at this right now is that these things that you state in the first paragraph, that you've come of full age, that you want a people found to have been living, so on and so forth, right? These things that you're stating in the first paragraph do not rise to the question and the aspect of a fact. That doesn't come in until you come down to your statement of facts and your specifics. Down here you would say, plaintiff is one of the people of Illinois. Plaintiff has come of full age. And you do this in separate lines. You'd say, so that one fact per line as you're going down. So only one fact per line, one fact per line, one fact per line. And only the who, what, when, and where. Okay? Which I should actually probably make a note of in here. But anyway, you can make a note of it yourself under the facts. So you say who, what, when, where, and how you felt. How you felt can be a fact as well. I felt terrorized. I felt scared for my life. I felt, whatever. I felt he was going to kill me. Right? So those are the things that you can state as facts. Not the why. You never state the why because you don't know why I necessarily did it. That's a conclusionary statement that you save for your conclusions. Where your conclusion is you put the facts and the law together, and then you can say things like, okay, because of the concealment of material facts regarding blah blah blah, defendant is guilty of fraud. Okay, that's then you can put the whys in your conclusion, but you leave the whys out of your statement of facts. Okay, so just to have this open up, now let's go back to showing what a fact is in the definitions here. Fact number 3 here. It is also put in opposition to the law in every case which has to be tried. There are facts to be established, and the law which bears on those facts. Facts are also to be considered as material or immaterial. Material facts are those which are essential to the right of action or defense, and therefore of the substance of one or the other. These must always be proved, or immaterial, which are those not essential to the cause of action. These not need to be proved. Like, it was a cloudy day. Okay. So what? Immaterial fact, right? Doesn't matter. Doesn't have to be proved one way or the other. Doesn't go to the merits of whether the guy was guilty or not. It doesn't matter if it was a cloudy day. So that's an immaterial fact. It could have been a fact it was a cloudy day, and somebody else might say, well, no, it was sunny. Doesn't matter. Immaterial, right? But if they say, hey, I saw a man run out of the house with, a chest under his arm or something, and someone else says, no, I saw a woman run out of the... Well, that's a material fact, because now you're getting to the point of who done it. That's a who. Or if they say, well, I saw a man run out with a chest, and the other guy says, well, I saw him run out with a dog. Okay, that's a what? That's a material fact. Like, what did he run out of there with, right? So you got material and immaterial facts. Number 5, facts are generally determined by a jury. But there are many facts which, not belonging to principal matters in an issue, may be decided by a court, such as, for example, whether a subpoena has or not been served, whether a party has or not been summoned, as to pleading material facts. Right? So it's more from the standpoint of facts regarding due process and of that ilk are facts to be determined by court instead of the jury. So you have your facts, and you state your facts in your case. So now what's evidence then? Evidence is that which demonstrates, makes clear, or ascertains the truth of the very fact or point in issue. So evidence would be, I saw the man run out of the house with the dog. Okay, eyewitness testimony. It's evidence. Better evidence would be a videotape of the man running out of the house with the dog. Okay, that also can be placed as evidence. Now, if that evidence of that man running out of the house with the dog happened to be the owner's video camera, and there was never a proper warrant signed out by a magistrate to obtain that videotape, that evidence can then be stricken from the record. You move to strike that evidence from the record because it was obtained without due process and in violation of the accused's rights to attain that evidence. Okay, so just keep that in mind. So to continue, it is whatever is exhibited to a court or jury, whether it be by matter of record or writing or by the testimony of witness, in order to enable them to pronounce with certainty concerning the truth of any matter in dispute. So we have whether it be by matter of record. Okay, what does that mean? That means public record is the highest form of evidence. Okay, so when you put your status docs, the things that you've recorded onto public record as far as your status is concerned, and they're a matter of public record, that's the highest evidence you can have. Then goes to other writings that's signed or sealed, and then testimony of witness is like kind of on the low side of things. And all of the evidence is then brought forward to state your fact and prove your fact. So the fact that you're one of the people, right? Or the fact that you were born in such and such state, right? That'd be public record. So to continue, evidence in priority, I don't know. It is that which is legally submitted to a jury to enable them to decide upon the questions or in dispute or issue as pointed out by the pleadings and distinguished from all comment or argument. Evidence may be considered with reference to 1, the nature of the evidence, 2, the object of the evidence, 3, the instruments of the evidence, 4, the effect of evidence, and then 1, as to its nature. Evidence may be considered with reference to its being, primary evidence, or secondary, positive, presumptive, hearsay, and admissions. So you can go through those. Primary evidence is eyewitness testimony. So that's primary of the witness. He says he saw something such and so. Secondary evidence could be things like, oh, there was a footprint and it matches a shoe kind of thing. The difference between positive and presumptive, I'm not exactly 100% sure about. So that might be things we'd have to look up. Hearsay is something that someone says based upon what somebody else said. Oh, I heard him say blah, 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 right? That's hearsay. And hearsay is not admissible. And then admissions are where someone admits something into evidence and admits that they did it, or that, yeah, the dog was theirs, and they admit that they were such and such a place on such and such a day, or that they weren't such and such a place on such and such a day. So primary evidence, the law generally requires that the best evidence in the case admits should be given. For example, when a written contract has been entered into and the object is to prove what it was, it is requisite to produce the original writing if it is to be obtained, and in that case no copy or other inferior evidence will be received. So, the question is, how do they get around that one when it comes to mortgages and notes, right? They can't produce the wedding note. That's the whole point. They shred the thing. They put it into the secondary market under mortgage-backed securities. Basically, how do they get away with it? It's corrupt judges. It's just that's your answer. Really is no other answer other than that. To this general rule, there are several exceptions, as it refers to the quality rather than the quantity of evidence. It is the evidence that is the fullest proof that every case admits is not requisite. If, therefore, there are several eyewitnesses to a fact, it may be sufficiently proved by one only. It is not always requisite when the matter to be proved it has been reduced to writing, that the writing should be produced, as if the narrative of fact to be proved has been committed to writing, it may yet be proved by parole evidence. A receipt of the payment of money, for example, will not exclude parole evidence of payment. So this is where you're kind of getting into the aspect of, well, if I had a contract and you don't produce the original contract, but I produced the bill that the guy signed when he paid me as a receipt for it, well, okay, you can come in and say, yeah, I painted the guy's house and here's the receipt. What's the problem? That's kind of what they're getting at there. I won't go through the rest of the different kinds of evidence. Just know basically that the aspect of evidence is something that proves the facts, okay? So I'll just leave it at that because evidence is pretty lengthy, as you can see here. Goes on for quite a while. And we'll get down to the law now. Now this is going to get pretty difficult to follow. I'm not expecting everyone to commit this to memory, clearly, because even though I talked about the 5 jurisdictions of law and American jurisprudence, this is going to get into all kinds of different things. So try and follow me here. If you get lost, trust me, I got lost the first time I went through it as well. Law. In its most general and comprehensive sense, law signifies a rule of action, and this term is applied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational. In its more confined sense, law denotes the rule, not of actions in general, but of human action or conduct. The law is generally divided into four principal classes. Okay, so these are your classes of law. Natural law, which is the rights, like your right to defend yourself. Okay, that's an aspect of natural law. Your right to be left alone, also natural law. So remember, we're dealing with classes here. So natural law is class. Law of nations is a class of law. That's the law between nations to deal with treaties and tariffs and the like, right? And let's not go to war with each other kind of thing, right? Public law, this is do no harm. This is damage, harm, loss, and injury stuff. This is public law, not public policy. Public law is a harm. Public policy is Roman civil law administering infants. Okay, that's public policy. Public law is harm. And private or civil law. And this is, of course, private and civil law. This is an aspect of things like municipal law, right? Because we say you live here, you're whatever, subject to blah, 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 right? So when considered in relation to its origin, it is statute law or common law. So there's only two origins of law. Okay, notice that. As to its origin, it is statute or common law. The only two forms you got. When examined as different systems, civil, Roman civil law, common law, and canon law. Those are the only three systems of which you can prosecute somebody under. Out of those three, which one should you pick? The middle one. When applied to objects, it is civil, criminal, or penal, and is divided into natural law and positive law, into written law and unwritten law, which is what I spoke about before, and then into law merchant, martial law, municipal law, and foreign law. That's another way of kind of chopping up these other aspects of it. When considered as to their duration, laws are immutable or arbitrary or positive, and when as their effect, they are prospective and introspective. And all of these stuff will be considered differently. So that's one hell of a paragraph to try to chop up. The main thing that I want people to realize is that there's only two different origins, statute or common, and that there's four principal classes: natural, law of nations, public law, and private law. Now, technically, common law kind of falls under public law, but you can also consider common law also falling under the aspect of natural law, because your customs of a people stem from an aspect of natural law, so that's in connection with, right? So I'm not going to read all of these. I went through some of this before. You can read about canon law, specifically where it comes from. This is Roman civil law. The term civil law is generally applied by way of eminence to the civil or municipal law of the Roman Empire. Okay, notice that. Roman Empire. Without distinction as to time when the principles of such law were established or modified. In other senses, civil law is that collection of laws comprised by the institutes, the codes, digest of Justinian, and some of the other people. So civil law is always Roman law. Civil law is always Roman law. Just remember that. Common law. The common law is that which derives its force and authority from the universal consent and immemorial practice of the people. So it's distinguished from the statute law and has never received sanction from the legislature. It never will. It's above them. The phrase common law. The term is used in contradistinction to equity, admiralty, and maritime law. That's important. Contradistinction. Separate from these other creatures. Okay, these other creatures that they try to pull you into. Law merchant, this is something that's important. A system of customs acknowledged and taken notice of by all commercial nations, and those customs constitute a part of the natural law of the land, only from a standpoint of what the merchant has brought on the land, basically. And being a part of that law, their existence cannot be proved by witness. Yeah, well, surprise, surprise. But the judges are bound to take notice of them. Notice of what? You can't... Anyway, you get the point. Municipal law, this is just another aspect of Roman civil law. Law of nations, this is what I spoke of before. It's kind of basically establishing universal consent among all the civilized inhabitants of the world, sort of. It's mostly treaties, is what more or less what international law is. The natural law of nations, consisting of rules and applicable to conduct of states. The positive law of nations, which consists of voluntary laws of nations derived from presumed consent of the nations arising out of their general usage. The conventional law of nations derived from the express consent of nations as evidenced in treaties and other international compacts. Like I said, it's mostly treaties and compacts. Law of nature, this is a more interesting thing to read. Primary laws of nature may be reduced to 6, namely comparative stagnancy or reason, meaning, do you have reason? Did you ever is there a logical reason for you to have done what you did? And if you have a logical reason to do it, then guess what? It's natural law. Self-love, meaning self-preservation, so you have the right to self-defense, obviously. The attraction of the sexes to each other, right? So men and women can marry and do their thing. The tenderness of parents towards their children, meaning the defense, that you have the right to defend your children. The religious sentiment, meaning you have the right to believe whatever you wish to believe as far as your religious beliefs are concerned. And your sociability, if you want to be left alone or not, right? So there you go. These are your basic aspects of natural law, or law of nature. And the rest of this other stuff is kind of fun too. Some of it's a little bit out of date, obviously. There's some kind of funny stuff in here, but anyway. And then I have the rest of the aspects of law from Bouvier's. Now, why am I bringing this all up? Okay, what's all this craziness about all this various different law? Who cares, right? Well, the point is that when you're doing your law, oh, by the way, there's the laws of Oleron, which I spoke about brought back from Eleanor. So the point of all this is that when you file suit in a court of record, it has to be what? Common law. Okay. So what is the common law? Well, in some states, the English common law has been adopted by statute. Okay. There is no general rule to ascertain what part of the English common law is valid and binding. To run the line of distinction is a subject of embarrassment to courts, and the want of it a great perplexity to the student. Right, because they're not going from a standpoint of what it is. It's basically the king's prerogative. So if you're sovereign, it's your prerogative. So how do you do that? Well, let's go back to our court. So go open up our little case here, okay? So our court of record template. So what are we doing? Introduction, what happened? Venue, where are we doing it? Commencement, this is how we're going to do it. So this is an action at law in a court of record wherein plaintiff seeks to recover damages for the defendant for the following injuries. Blah, 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 whatever they did. Who, this is your who. This is your what, when, and where, and how. This is how you have jurisdiction, your jurisdictional clause. That, so-and-so got served and they're in the proper jurisdiction because the stuff happened in the county or whatever. And plaintiff, by common law, expects the defendant to present plaintiff with a property that's safe to live in. That was from an aspect of, I did this for somebody that they moved into a house and it was black mold all over the place, which the guy lied about and didn't tell him about, whatever. So it was an unlivable scenario, and then he still wanted to get his money. So, but whatever else they did. So the fact that, what is your jurisdictional clause? What the attorneys will always do first in any cases, they'll say, you failed to state a claim upon which relief can be granted. That's their boilerplate, stupid motion to dismiss. Always. Every single attorney, that's the first thing they're taught in law school. File a motion to dismiss upon failure to state a claim upon which relief can be granted. Well, then state the relief. State the claim. Tell them why. This is the reason. Okay? So they can't do this. This second part, number 15, this is basically one that you would do as a counterclaim or counteraction used against you if someone was charging your estate, like a traffic ticket. So this would go into that. And then we finally get down here to the law of the case. This is where you decree the law of the case as a sovereign plaintiff in your own court of record, because that is what kings and queens do. How do you do it? Attachment H, law of the case is incorporated by reference as though fully stated herein. That's so you don't have to all repeat it in the same. You don't have to repeat it in this document. You can just put it as an attachment, and applies to all causes of action and all declarations at law in this court of record regarding this case. So now we've got our facts. The evidence will be where you evidence that you bring in a case will be things like your exhibits or your admissions of evidence or your attachments, whatever. Those are the things that are your evidence of your facts. So in this scenario, it was on such and such a date, plaintiff entered into a contract to lease the property located at wherever. That's a fact. Okay. What do you say after the fact? See Exhibit A. What's this? The evidence. Exhibit A, lease contract, which is incorporated by reference as fully stated herein. So that way you don't have to repeat the whole lease contract. You say, here, look at it. Then when you get to court, what you got to do when you're formally presenting all this information to the jury, you're saying, and I now enter this lease contract as Exhibit A onto the record. And that way, then the jury gets to see that, yep, there's a lease contract. Yep, we'll get to see it later. But then the point is that the defendant gets to say, hey, objection, I never saw that lease contract. I don't know what you're talking about, right? Or whatever. Now, all of that kind of stuff, all that sort of back and forth argument about the validity of evidence and whatnot, it should all get taken place prior to trial, because trial is where you are formally bringing and presenting the facts and the evidence to the jury. At that point, the other side should have had ample opportunity to see everything that you're going to present and everything that's there. So you can't do what's called trial by surprise. Now, at common law, remember, there's no discovery at common law. Remember that. So what happens at common law is that you have to put everything onto the record when you file your case. And I mean everything. Every exhibit, every bit of evidence, every fact, all the law, all of it. You enter all of it at once. There is no discovery at law. So you place the whole entire thing, the whole kit and caboodle, into the case. So that when the opposing attorney, of who's ever defending the defendant, opposing attorney says, well, we want discovery on blah, blah, blah. You say, that's frivolous. Objection, Your Honor, that's frivolous. Well, why would it be frivolous? Well, Your Honor, this is a court of record. It proceeds according to the course of common law. There is no discovery at law, Your Honor. It's frivolous. Right? And then if the judge overrules you, which technically you can't do if you're a plaintiff in your own court of record, you say, well, Your Honor, for the record, I do object. And then he says, he'll usually say, okay, your objection is noted. Then what you do is, after the hearing, what you do is you go back home to your computer and you type out writ of error. It says, hey, this Judgy Poo went a little bit crazy and thinks he's running this court here. And so we're going to hold a contempt hearing for a day and find out just exactly where this crazy fool's brain's at. And so you hold a contempt hearing and the judge gets a chance to explain himself. And he says, so, Judge, how come you overruled me? Or how come you did this or did that against my wishes? You know, where I'm the plaintiff here. And this is my court. And unless he's got a good reason, you can hold him in contempt too. And that's how writs of error are supposed to be done in courts of record. Now, a lot of the time, you'll see writs of error being done where they will write up a writ of error and then they'll take it to an appellate court. Okay, that'd be fine in equity or ecclesiastical or maritime admiralty or, well, I don't think it happens in court martial, but anyway, the other three. There's a slight problem, though, when it comes to courts of record, and that is the fact that the decision of a court of record is final, and there is no appeal at all from a court of record. That's the problem. So, and by the way, if you want proof of that, all you got to do is go back and click on the law of the case again. And let me find the holding here. And by the way, this law of the case is this is the same you can pull off of 1215.org. I have a much longer law of the case, which I believe is on the server that I've placed previously, regarding the courts of record not being able to be appealed. I may just have to go get that. I just want to make a note that all that case law that's in my law of the case, the merged, it's not all been shepherdized. So just make a note of that to shepherdize all that case law, because the stuff that's in red in my case law is I have not yet shepherdized. I mean, I've collected it over the years, but I haven't had a chance to go through it, all of it. But the point is that I just want to find the one case regarding the court of record real quick. There, this one. I'm going to copy and paste that into the chat. Okay, so no statutory or constitutional court, whether it be appellate court or Supreme Court, can second guess the judgment of a court of record. The judgment of a court of record whose jurisdiction is final is as conclusive on all the world as the judgment of this court would be. Speaking of the Supreme Court. It is as conclusive on this court, meaning the Supreme Court, as it is on all other courts. It puts an end to inquiry concerning the fact by deciding it. So, there is no appeal from a common law court of record, which makes perfect sense. If the sovereign, in their sovereign capacity, is bringing a court case, and the sovereign people, 12 members of the jury, say, yeah, this is what we're going to do, and that's the end of it. Who can that possibly be appealed to? Nothing. The only thing that you could possibly do with a court of record case would be if there was some sort of gross misconduct or due process violation, say, that the magistrate said, hey, wait a second, did you serve that guy? Or, whatever. And it was brought up on objection in the trial court, but then nothing was done about it. And it turned out to be a denial of a substantive right, whether plaintiff or defendant, doesn't really matter. Then they would be able to you're basically suing out a brand new, it basically becomes like its own action, and you're kind of suing out the whatever the problem was. So there's checks and balances through it. It's not just that the court of record is completely all-powerful, but they're very limited. Another one, the acts of a court of record are known by its records. Judicial records are not only necessary but indispensable to the administration of justice. The court judgments can be evidenced only by its records. The acts of a court of record are known by its records alone and cannot be established by parole testimony. The court speaks only through its record, and the judge speaks only through the court. So again, is the judge the court? Nope. What's the court? The court's the record. And the sovereign. Below that, inferior courts are those whose jurisdiction is limited and special and whose proceedings are not according to the course of the common law. So if you're being charged with a statute, you know you are not in a court of record. You're automatically in an inferior court. And you should call them that. You should say such and such inferior court. Right? Such and such judicial district, state of Iowa, inferior court to the superior court, court of record. So they'd be basically a counter defendant. And the corporate state, whoever coming up against you. Those would all be counter defendants when you bring a suit challenging the jurisdiction of their inferior court. And the point is that they have to prove it. They have to prove the jurisdiction to your superior court. Can't just be because we said so. No, you have to prove it. So, and a little interesting piece of history here. The thing below this I throw in here from the standpoint that I found it in the 1818 Illinois Constitution. But you can find the words court of law and court of record in, I think, every single state constitution. I don't think that I've ever found one that doesn't have these terms in it. But anyway, my law of the case is 52 pages. I'm certainly not going to go through all this. But the point is that basically you say the law of the case is decreed as followed, colon. And then you leave in as much of this. And by the way, all my law of the case is in categories too. So it's easy to pick and choose and drop stuff in, whatever. But yeah, so this is the law of the case. So now we have, so we've got law of the case. So we've got law, we've got our facts, and the evidence is what? It's the exhibits that you place into the case to prove the facts. Okay. Leave this for a second. Let's go back to checking I want to go through. So this was I'm going to put these up on the screen side by side just so I can kind of show you how the flow of this goes here. If you guys don't have screens big enough to do this, it's okay. I don't know if you'll be able to see it on mine. What I'm going to do is I'm going to put these side by side here. Template, the completely blank template on the right, and then we have the kind of filled in template, which is a template it's a template pretty much for a traffic case is pretty much what this is. So let's go through how to do this now. Whenever you get a charge against your state, so they'll put in, it'll be state of whatever, state of Iowa, plaintiff versus usually John H. Doe, but it'll be all caps, right? Okay, so that's the constructive trust that they're creating. Case number, whatever, and then da-da-da. So what you do is what you would do is what looks like here on the left-hand side, okay? This is a proper caption for a counterclaim, okay? So the original thing, you've got plaintiff, state of Iowa versus defendant, the res defendant. I always do that just because I like to throw it in their face that I know what they're doing. So res, John Frando, whatever. Case number, blah, 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 blah. This is the original action. This is what the state was doing in equity, right? Maritime, amnesty, ecclesiastical, probate the estate, blah, blah, blah. Because like I said, they're running all the jurisdictions at the same time. So what you do is underneath this thing, you say, okay, now I'm a counter plaintiff. John-Henry, House of Doe. A man versus counter defendants. State of Iowa, a corporation. Jack Van Berkum, a man, and the Iowa District Court for Boone County, a corporation. Case number, this is the importance right here. This case number must be an at-law number. Be very careful of this. The clerk will try to give you, and they will try to assign you, an equity number. They do this all the time. To just screw with people, okay? So you have to say, file on demand, or I file this on demand, and demand that you give me an at-law case number. Or you could say, I demand this be filed at law. I demand that this counter suit or counter claim, because it'll depend if the clerks want to get pissy about the difference between counter claim and counter suit, don't argue with them about that. Doesn't matter. Just call it a counter claim. Who cares? Which is technically an equity term, but whatever. Just go with it. because it's not going to change anything different in the body of the case, okay? Because headings don't control. It's just from a standpoint of the clerk knowing where to file the thing, okay? They don't control as far as what's in the body of the case, what the case is actually about, right? So, but as far as that case number is concerned, you better goddamn well get that thing right. Make sure, do not walk out of there with an equity case number. And usually you can tell equity case numbers because they usually say EQ in front of them. And most of the time, at law numbers will have an AL, or they will just have an L, or sometimes they'll have an LW in front of them. That's how you know it's at law. If you're confused, or if you have any questions whatsoever, or preferably prior to even walking in there and getting a case number, you can do an open records request, Freedom of Information Act type thing, whatever, to demand that the clerk produce for you the abbreviations of the case numbers. They have to give them to you. Okay, that's another way to get a hold of them beforehand, so that you know when you're walking out of there you do have an at-law case number. They can't deny it to you because you're doing it as a matter of right. Okay, so you get an at-law case number, and then you got your claims, whatever they are. So claim an action trespass, claim an action of trespass in the case, claim an action of non-assumption. Now, you don't have to say claim in front of all of them. Some people like to do that, some people don't. It doesn't really matter. You can just say action of trespass in the case, action of non-assumption. But the fact that it's at law, you'll be making the claim in the body of the suit anyway. So as I said, this is kind of set up for a traffic ticket, right? So now the order of these things is a little bit different. This is why I gave you both templates, because one kind of has more of the proper meat in it as to what you would want to say, and then the other one is properly laid out as far as the order of which things need to be in. Because if you scroll all the way down to the bottom of the court of record template, down here I have a bunch of notes. After the suit's over, there's just a bunch of notes that I have in here. So after this, after test day, whatever, that's the end of the suit and your seal. So I have a bunch of notes under here. Well, one of the things I have is notes, including a bunch of lists of actions at law. So ejectment, debt new, replevin, debt, covenant, account, so on and so forth, is a definition of a declaration. Okay, again, Pouvier's. Now here's the point. The declaration in an action at law answers to the bill in chancery, the libel of the civilians, and the allegation of the ecclesiastical courts. Okay, I did get that right. So the declaration is within the action at law and not the other way around. So you have a declaration at law, you got a bill in chancery, you got a libel in Roman civil law, you got an allegation in the ecclesiastical courts. And like I said, you have a court martial in military, which they didn't mention, but whatever. So what's a declaration? It's a pleading. A declaration is a specification in a methodical and logical form of the circumstances which constitute the plaintiff cause of action. In real actions, it is most properly called the count. So when you have these things, in your, when you have these things in here up top, here, this would be count 1, action trespass. Count 2, action trespass in the case. Count 3, action non-assumption, right? So those are the counts. And let's get back here. The general requisites or qualities of a declaration are first, that it correspond with the process, meaning the original writ of summons. A lot of original writs don't exist anymore. The subpoena still does, though, however. And a writ of subpoena or a writ of summons, which is the thing that gets attached to the lawsuit that says, hey, show up and plead your case here, that you serve on the other party, that still gets attached. In general, the correspondence of the parties contains the best evidence of facts to which it relates. So the original written declaration must have the same facts within them and correspond with each other is the point. So anyway, so getting down here to what I'm getting at, the parts and particular requisites of a declaration are, first, the title of the court and term. So that's, okay, so what are you doing? That's your court. So what we say is action trespass on some declaration. So your title of your court and your term. I have the venue here started. Like I said, this one is not in order properly. This one that is part of the declaration here is in order. So you've got your title of your court and your term. Well, actually, I guess this is kind of right. So the venue, the commencement. Okay, so the commencement should technically be before the law. But, in a way, there's nothing saying that these have to be in a specific order. They just usually are. So the commencement, what is termed a commencement of the declaration, follows the venue and the margin and precedes the more circumstantial statement of the cause of action. It contains a statement, first, of the names of the parties of the suit, if they sue or be sued in another right or capacity. So you'd say Mary Smith, executor of Jane Smith estate or something like that, right? So that's if they're sued in some other kind of capacity, or in a political capacity as executors, assignees, quid tem. Okay, that's the point. of the character or right in respect of which they are parties to the suit, of the mode in which the defendant has been brought into court, and a brief recital of the form of action being proceeded in. So, what do we have here? We got a commencement. Commencement for all actions, so you don't have to repeat yourself every time, in the various different counts below. Comes now, John Henry House of Doe, who is at all times mentioned in the following declarations and actions at law, one of the people of Iowa. So what's that? That's your capacity. An American citizen, also capacity. Having come of full age, capacity. Having been found to be living, capacity. Competent to give testimony stated herein, capacity. Hereinafter, counter plaintiff. The reason you do this, the hereinafter counter plaintiff part, is so that you don't have to keep repeating all of this, or even keep repeating your name. All you have to say in the rest of the document is counter plaintiff. And what does it mean? Everything you just stated. Okay. Saves you a lot of paper. And in this court of record, hereinafter superior court, so there's your court, right? So what did you do? So where's your court? Yep. Statement of the cause, right? The commencement tells it what are you doing, where are you doing it. Comes upon an action of trespass in the case, and non-assumption against whoever, that's him. The Iowa District Court for Boone County South, which is a corporation, capacity, that has a Dun and Bradstreet number of whatever. That's technically a fact, but I threw it in there. You should name it as a fact later, though. Hereinafter inferior court, again, so you don't have to keep saying what this thing is over and over. You just call it the inferior court. And the state of Iowa, which is a corporation, capacity, and franchise the United States Federal Corporation, capacity, emanating from the District of Columbia, again, capacity, hereinafter singularly counter-defendant or plural counter-defendant. So whenever you're talking about all these sons of bitches, you just say counter-defendant or counter-defendants, and then you don't have to repeat all this garbage. And calls upon each of them to answer the counter plaintiff in these. You can also say summons if you want, because if they're dead things, whatever, summon them, or demands from each of them to answer the counter plaintiff in these said actions in the superior court to wit. So then, what do you got after that? We've got our statement of the cause. If action, in which all the requisites are certainty before mentioned must be observed, necessarily varies according to the circumstances of each particular case and the form of action, whether an assumpsit, debt, covenant, debt, new case, trovert, replevant, whatever. And these things you can understand. Wait, hold on, I better mark this. These different things, okay? All these different things we're just talking about these different actions. When you get up here and you're looking at the different actions, plaintiff causes of action, right? And this is just a short list. I have other causes of action, and everybody can find lists of causes of action and all kinds of various different things. If you want some more, I believe I do have Yes, I believe Jurisdictionary has a cause of action. If I remember correctly, they have a list of causes of action in here. That's all audio stuff. Okay, where's your causes? There it is. Okay, is that big enough? Yeah, it'll fit. Okay, so what I'll do, don't tell the owners of Jurisdictionary I'm doing this. Ha ha ha. So anyway, there's another list of causes. Jurisdictionary is a program that's based in equity. It's based in equity procedure, but it's very, very good in some respects as to things like this. That they can give you other lists as far as causes of action are concerned. We can learn about these things and say, okay, what needs to be proven in order to win this cause of action, right? And there's a name for that. Okay, elements, that's what it is. Each cause of action has a set of elements that must be proven in order for you to win. Okay? So you have to focus on making sure that can you prove all of these elements? If you can prove all of these elements in a cause of action, then you can win the case. That's all there is to it. Okay, court and satisfaction. Let's pick one that somebody might have a little bit, that we might have a little bit more familiarity with here. Okay, account. Well, they now call it accounting, but okay, this is a common law action, right? I was talking about an action of account. Okay, so give me an example. A cause of action for accounting arises when there's a fiduciary relationship, right? Again, so you have to prove the fiduciary relationship, such as where one party has a dispute with a guardian, trustee, receiver, or other fiduciary has control over assets of a party complaining. Well, guess what? That'd be us. Accountings may also be ordered where the issues in a contract case, for example, are so complicated that it is not clear if the fact has been ascertained as any other way, and always where the underlying contract has provided for an accounting in the event of a dispute. So what do you have to do with an accounting? What are the elements that you have to prove for an action of account? To successfully plead an action for accounting, or an action of account, one should assert the following. These are the elements. The existence of a fiduciary relationship or contract demands that are so extensive and complicated that it is not clear that money damages alone are adequate. And the necessity for the accounting. That's it. Those are the two things you have to prove. The remedy sought, 1, is an equity. Therefore, the court has broad discretion in whether or not it will grant the relief sought. It is important, therefore, to allege sufficient facts to make clear that justice and fairness demand that an accounting be given. Okay, the remedy sought is one in equity. Well, guess what? You can do an action of account at law too. So that's not entirely true. Okay, now that's the thing you got to watch with jurisdiction here, because like I said, this is all equity based, and this was written long after they merged or have tried to merge equity and law. So you'll get confusing things like this. But anyway, if you want the true, some of the true aspects of the different actions at law, then this is the better list. It's a short list, but it's a good list. As far as the one that I have in the court record template, the best used one. So down at the bottom of it, you'll have the actions at law. So you got trespass, which is an injury committed with force, actual, implied, immediate, and not consequential. If property involved, then property was the actual or constructive possession of the plaintiff at the time of injury. Anybody comes up and touches you, that's trespass. Anybody comes up and touches you and they happen to be displaying a deadly weapon, that's called trespass de armas. Okay. Trespass on the case, now this is a form of action by which a person seeks to recover damages caused by an injury unaccompanied with force. So things like, he moved a record or stole a record or changed a record or altered a record or something like that, which results indirectly from the act of the defendant, is more generally just simply called case. Trespass and trespass in the case are supplementary to each other, and it may be said in general, trespass in the case lies where no other theory or form of action is available. So, if there's no theory or form or action available for what you want to do, you just call it trespass on the case and write up the case. Doesn't matter. Do what you got to do. And then the rest of these, trover, ejectment, so on and so forth, you can read about those later if you want. But those are all actions at law. So, point. Statement of the cause. So let's get back and looking at the action here. So we got statement of the cause of action, trespass in the case. This is an action and trespass. This is an action and claim of trespass in the case, in a court of record, under the common law, to redress the deprivation of a custom or usage, unalienable right, privilege, or immunity secured to the counter plaintiff by the 1st, 4th, 6th, 7th, 9th, and 10th articles of the Bill of Rights as amendments to the Constitution for the United States of America, the 1st, 2nd, 5th, 7th, 9th, 10th, 16th, 17th, 19th, 20th, and 23rd articles, sections of Article 2 of the Bill of Rights of the Constitution of the state of Iowa, or whatever they are, right? So these don't even necessarily fit. So make sure that you get your amendments right, and so and so and so and so articles of this Constitution. So you grab your bills of rights. So this is what you're bringing on as far as the cause. They trespassed upon these things. Do I need to say? I had these rights. You trespassed upon them. Then how they do it. All of which the counterplaintiff is and was protected by it at all times mentioned, and in all causes of action stated herein, and further the jurisdictions of this court is invoked upon the same. So what do you do to invoke? You just do it constitutionally. That's it. You're doing a constitutional counterclaim. Counterplaintiff seeks an order, judgment, and execution of the Superior Court, finding and declaring that the counter-defendants have exceeded their jurisdiction regarding counterplaintiff's substantive rights, and seeks a judgment from the Superior Court for the damages stated herein as a result of the injuries caused by the counter-defendant, and the harm they have caused the counter-plaintiff in excess of said jurisdiction. The second that they come out of their box, as far as state trustees is concerned, that's called exceeding their jurisdiction. So once they jump onto your side of the fence and they exceed their jurisdiction, they come over here, they've come out of this box that they got put in the Constitution. They're in a box. That's all they've got. They jump out of the box, they've exceeded their jurisdiction, then they automatically trespass upon your substantive rights. That's the whole point here. See Attachment A, Law of the Case, for all of the law referenced herein. The same is incorporated by reference as if fully stated herein. So you put all this stuff, even though you just stated it here, you put all this stuff, all of this, whatever you're doing for your law, in the law of the case. Okay, now you get onto the several counts. So what are we doing? A declaration may consist of as many counts as the case requires, and the jury may assess entire or distinct damages on all counts. And it is usual, particularly in actions of assumpsit, debt, and simple contract, and actions on the case, to set forth the plaintiff's cause of action in various shapes and different counts. So if the plaintiff fail in proof of one count, he may succeed in another. Now that's Blackstone's for you. Smart guy, saying, hey, if you miss on one count, well, you might get on another one. So put as many in there as are applicable. Count 1, trespass, specifics. Statement of facts. Counterplaintiff now states the following facts regarding the events of September 9th in the year 2017 and after, and declares the same in these causes of action to the best of his knowledge and recollection to wit. At all times mentioned herein, counterplaintiff is and was one of the people of Iowa and American citizen. Now, technically, that's kind of two facts there. I should probably separate those. But anyway, you're getting into your specifics of your trespass case. So you're talking about what are you doing? Okay, now you're laying out all the facts of the trespass case. I'm not going to read all these, but they're all basically based on a traffic case. For example, the road name or known as 230th Street belongs to the people of Iowa for their use and enjoyment. What did you just do? You just made the state have to prove that fact incorrect. They have to come along and say, no. We admit or deny the following statements of fact. Are they going to deny that? They better have a fact to prove it, because this is what you're saying. You're claiming that the roads belong to the people. This road that I was on belongs to the people of Iowa. Are you going to deny that fact? Yeah, let a jury find that out. Okay? Here's another interesting one. After Jack Van Berkom handed the said presentment to the counterplaintiff stated to Jack Van Berkom on the side of the road, named or known as whatever street, I do not wish to sign that contract. Jack Van Berkom then stated to the counterplaintiff, you do not sign it, I'll take you to jail. To which the counterplaintiff replied, then under these circumstances, I'm going to sign it because I do not want to go to jail. What did you just prove? You just proved duress. So as long as you do this kind of stuff on the side of the road, you can state it. Hey, look, I never entered this contract willfully. Screw you, right? The counterplaintiff then signed the contract under duress without any effect or validity. See admissions of evidence I, sworn statement of Jack Van Berkom, admitted on the stand under oath in the inferior court. See the law of the case, maxims of law, due process, contracts, consideration, to understand the law regarding these admitted acts, right? This was a place where a stupid land pirate had already taken the stand, and he admitted to this. So anyway, when we brought in the counterclaim, we said, all right, roll that in there. Anyway, so like I said, I'm not going to go through the rest of this, but it's based on stuff on traffic court stuff, and a lot of facts there are. Conclusion. So you get done with your facts and you give your conclusion, because you've got your law up top. So now you put your facts and your law together, make a conclusion. So, right? So sixthly, the conclusion. In personal and mixed actions, the declaration should conclude to the damage of the plaintiff, unless in severe fashion of penal actions at the suit of a common informer. So now you're putting your facts and your law together and you're making conclusions. Counter-defendant Jack Van Buren has, without lawful right, trespassed upon the right of counter-plaintiff. Use color of law as an authority to deprive counter-plaintiff of his right to use the roadways for private use, and has exceeded his jurisdiction as a duly sworn sheriff deputy under oath without cause and without lawful authority. Conclusion. The above actions and or omissions of the counter-defendant Jack Van Buren were so grossly negligent as to amount to a deliberate indifference to and deprivation of counter-plaintiff's substantive rights, which are at all times protected by the state and federal constitutions as stated in the law of the case. When the counter-defendant, whoever, exceeded his jurisdiction as a sheriff's officer, he instantly became liable for any trespasses upon the rights of the counter-plaintiff. These rights are decreed and listed in the law of the case, and in the Federal Bill of Rights, Constitution as in vigor, and in the Bill of Rights of both the Iowa state constitutions. Because it said trespasses against counter-plaintiff caused by counter-defendant. Okay, counter-defendant Jack Van Buren now owes the counter-plaintiff damages. Okay, so it's this thing you got to remember. The injury is what they do to you. The damages are what you ask for to be made whole. So just remember that. Some people, when they first start studying law, they get that messed up. They're like, oh, he damaged me. No, he injured you. The damages are what you want back from him. Okay, so counter-defendant, state of Iowa, has produced no evidence on the record of the inferior court that would show that counter-plaintiff was engaged in commerce on the roads and highways, making the prosecution of counter-plaintiff by the counter-defendant state of Iowa malicious, unwarranted, and therefore, as such, is a trespass upon his substantive rights to be free of same. They don't have any proof you're in commerce. You're exercising a substantive right. What is that? To travel along the roads and highways which you own. To go from point A to point B. Period. Thank you. So, there's more conclusion stuff here, so I'll go through that. So you do the conclusion of your count, right? So there's your conclusion of your first count. Then you do your count 2, trespass on the case. Again, you do your facts. Oh, one little thing I got to add up here, tell you about. So when you go into your second count, right, instead of having to repeat all of the facts that you stated in your first count, you do this. Counter-plaintiff reaffirms and declares, again, paragraphs 1 through 46 above, and the same are included by reference in this count as though fully stated and set out herein. So again, what do? You just save yourself having to repeat all this stuff. So now you can start into the specifics of the second count, which is the trespass in the case. This is the case where it's non-fiscal, right? So you talk about what's going on, administer property, other things that happen during this scenario, which wouldn't necessarily apply to everyone. So you do your facts, and then you do your conclusion regarding the second count, action and claim of trespass in the case. So now you take the law that you had above, that you've decreed your law of the case. You take your facts of your second count, and then you do your conclusion of your second count. Include that one up. And you just repeat it. You see how this just keeps repeating and repeating and repeating. So now I got third count. Statement of third count. This is the cause of action. Again, all these clauses are repeated. Reaffirms and declares. Reaffirms and declares. Set out here. And always be check your numbers of your paragraphs. You don't screw this up. This is just, I'm sure these numbers aren't right from the above stuff. So pay attention. Do your paperwork right. So blah, blah, blah. A few more facts. And again, conclusion. Seventhly, the proffered and pledges in an action at a suit of an executor or administrator immediately after conclusion of the damages. Before the pledges, a proffered of the letters, testimony, or letters of administration should be made. Now, this is an action at law. This is not a probate matter. But when we'll do the formal probate proceeding, then the letters, testimony, and your executor appointment would go before the pledge. Okay. So, and at the end of the declaration, it is usual to add that the plaintiff in common pledges to prosecute John Doe and Richard Roe. So you say, pledge. The counter plaintiff in common pledges to prosecute the counter defendant at law in this court of record until all matters and actions are concluded to judgment as the common law requires. Done. That's it. Just got to say you're going to do it. And then your demand for relief and judgment is this declaration that may be general or special, for example, in debt or bond. Declaration counting on the general penal part in general, and when it sets out both the penal and condition, serves both the breach as special. Now, the demand for relief is actually something that's more from a statement, more of an aspect of finishing off kind of something in equity, but nonetheless, it pretty much has to be in here anyway, because you do have to demand what the hell you want. The demand for relief is kind of part of your conclusion. It's like another part of it. I just tend to separate it because when I do the demand for relief, I do it in this. I say, for the above stated cause of action, therefore, counter plaintiff brings a suit. For the above stated claims, counter plaintiff requires the foregoing relief. Wherefore, counter plaintiff requires relief and judgment against counter defendants as follows. And then on all claims and causes of action. So I lump everything together as to what I want, right? And so each of these things, all the counts, then get bound into whatever it is. This one for injuries caused by blah 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 blah. Damages the amount of 3 ounces of 0.999 grain gold. So you state your damages in amounts of gold. State your damages in lawful consideration. Do not state your damages in filthy Federal Reserve notes, okay? Or you basically negated your whole frickin' suit. So, and then you put a notice of default in here. This is to wrap them up into the aspect that you're giving them. This isn't technically part of all the parts of a declaration, but I put it in here so that, because you can do this from a standpoint of, if you use or declare the rules of your court, however you're going to run your court. So you could declare that the federal rules of civil procedure are the rules of your court of record. You can declare that the state rules of civil procedure are the rules of your court. You can declare that even though technically, which is kind of funny, a court of record proceeds according to the course of the common law, you being the sovereign, you can change the rules. So it's up to you. Because the reason you kind of want to do that is that it's very difficult to find a good book on common law procedure. Meaning, what happens after you file the suit? Because it's a whole different ball of wax going back and forth with a court of record suit than it is with a court of equity. There's different things that happen. There's different things that go on before you get to trial. There's certain things that the other party has to do, and then certain things that you have to do back and forth and back and forth and back and forth, and they get pretty lengthy. You're really trying to whittle everything down to a single issue, if you can. And that was kind of the point of common law pleadings, is that we get it down to this one issue of fact. Was it the dog? Was it him? Was it not him? Was it the chest? Was it not the chest? Whatever. And minimize the amount of facts that need to be at issue between the parties. And by the way, that's another vocabulary word for everyone. When two parties cannot agree on a particular fact, that fact is then said to be at issue. So now we have an issue before the court. Now we've got something for the tribunal to determine. Right? If there's no issue before the court, there's no reason for anybody to be there. So that means there is no controversy. So in the end here, you do a notice of default as far as your rules are concerned. You say counter defendants have 30 days from the service of process to answer counter plaintiff in all actions stated herein. Or the court will rule in favor of counter plaintiff and award counter plaintiff all damages stated in relief required above by nil dissent. And when you say nil dissent default judgment, it means nil dissent means he says nothing in Latin. So if they stay silent and they don't ever answer your case because they think, oh, this guy, it's weird, he's not following the rules, and I don't know what he's doing here, judge. Well, doesn't matter. You told them that you were going to default them in 30 days if they don't answer. Those are the rules. There it is, right there. Bam, done. They had their notice. It was right there in front of them. Not your fault, not your problem. So then you do the verification, which is counter plaintiff has personal knowledge of the above stated facts, am competent to testify as the truth of these facts, is called a witness, declare an apparent perjury and allows the United States of America and the common law of the foregoing is true correct, so on and so forth. Put your test day, sign it. You don't have to necessarily sign it twice. I don't know why I have a double signature line here. Actually, that should be wiped out, but anyway, doesn't matter. And then put your seal at the bottom, you're done. File it, serve it, get your calendar ready, start your days counting, take them out. That's how you do a court of record. It's not that difficult. You guys just have to learn some of this basic stuff. And luckily I gave you both templates here, okay? So I gave you the template, the complete blank template that you can kind of use for whatever. Just follow the parts of a declaration down at the bottom of this one. Just go through and write your stuff out and focus on your facts and your evidence. What can you prove? What can't you prove? If there's something you can't prove, don't bring it up. Or if there's something you don't want to argue, don't bring it up. That's certainly the point. That's an Abraham Lincoln quote. Abraham Lincoln did say, if you don't want to argue something, don't bring it up. So, with that having been said, we've gone through what our facts are, or who, what, when, where, and how you feel, not why. Your evidence is public record is the highest form of evidence, and then your exhibits and whatnot. And you can go through the definition of evidence again. Law. So what are you using for your law? The different jurisdictions, we covered those. And by the way, do not mix them. The aspect of this thing that they're calling one form of action to rule them all. Yeah, one ring to rule them all, right? So they're trying to bring everything to one filthy singular ring to say, well, this stuff is all mixed together. We don't know what... Well, there's a really good book. I believe it's called by Melvin Stamper, I recall. And it was called Fruit of the Poisonous Tree, which I believe I have reading. And he gives a really good explanation from the standpoint of like when this stuff changed and kind of what's going on, and from a pissed off attorney's point of view, which you don't really find too many of regularly. So it's a good read, and it shows you the aspect that this is like mixing this one, and this one, and this. Okay, so you mix all these things together. Basically what you do is if you tried to mix all these together and you put them in a bottle and shook them up, eventually the sand would go to the bottom, the water would sit in the middle, tar would be above the sand, and then the oil would be hanging around at the top if you just let the thing go. Right, all these things would work themselves back out if you didn't have the attorneys constantly trying to smash them together like some bunch of idiots. So anyway, know your law, know which jurisdiction you're in, and know why you're there, okay? And do the proper pleadings in your proper jurisdiction. And I don't particularly care what jurisdiction you're in either. You can win in equity as a defendant if you want to take 20 years to do it, because you're going to be going through appeal after appeal after appeal. And if you screw up one time in equity, you're dead. You miss one thing, you're screwed. So not exactly the kindest of jurisdictions to be in. This one's much more kind, and you can control yourself in this one. Because if you screw up, you just say, hey, I'm going to amend that, by the way. So you go and amend it. You can go and amend the entire case, and you can amend the whole thing. This case is amended in its entirety. Refiled, redone, reserved, done. No harm, no foul. Right? Because this thing's done, common law, this thing's done when you say it is. This thing's done through all kinds of goofy-ass rules that you don't control. And that you better be totally up to speed on unless you want to get run over by them, right? Same goes with this and all the rest of these. So declaration versus bill. This is just a real quick summary here between aspects of law and equity. So number 24, 7 parts of a declaration, 9 parts of a bill. This will give you a good side by side. So you have a bill in equity. So these are showing you the 9 parts of a bill in equity. And then these are showing you the 7 parts of a declaration at law. Just so you guys have a clear piece of paper that you can go to for reference, okay? I just gave that to you just so you can know the 2 differences. Which is kind of, I just did the declaration stuff before. But just remember, a bill is a chancery practice, right? There's the difference for you. Don't really need to go anything farther than that. That's just a reference material for you. So let's go over all aspects. Letters testamentary. Letters testamentary are, so a testament. Testament is like last will and testament, right? So letters testamentary is a thing that placed down into probate court, not something that placed into probate court. What it is something that comes out of a probate court of letters of something. So whether it be letters executor, letters of administration, letters of trusteeship, letters, whatever they are. Letters testamentary says, yep, that's what the testament says. That's what the court's going to create for you to go do whatever the hell it is you got to go do. Okay, that's the long and short of it.
Would that be like your kills warrant?
No. Kill warrant is an aspect of the will and a declaration. Letters testamentary are things that come out of probate court as to like the creation of it. It would look something more like the executor doc when it was done. But like I said, letters executor, letters administration, or letters administrator, these are things that come out of a probate court. And this might be what you guys are like confused about. Until you get done with your court of records suit, until you get done compiling it, the template that I showed you. Once you get done compiling it, and you have the evidence of various different things of what you're saying in there and the facts and whatever else, when you file the suit is when you get the number. You don't get the number until you file the suit. That's the point. That might be where you guys were getting confused at.
Well, I asked for a number, but I am in the process of trying to get the suit filed.
Yeah, but you won't get the number until you table your suit. Once your suit's recorded, then you get the number. It doesn't happen before that.
So what do? Just put a big blank on this thing and let her fill it in?
Yeah, up at top. Yeah, up at top you leave the case number open.
Okay.
That's all you do. And then they put the case number on it, and then they'll put a stamp on it. And then then that will be your file stamp copy. And what you want to do is you want to take, 2 or 3 copies with you. Take 2 or 3 copies of your suit and say, okay, I'd like this filed, and I demand that this be filed at law. And then you can write the case number in by hand if you want to, and then have her file stamp the copies. So you walk out with file stamp copies. Those are what you serve.
Okay, you serve that upon the person that's been being sued then.
Yeah, unless you want to do unless she asks you, because they'll usually say, do you need service? The clerk will ask you, do you need service on this?
Oh, okay.
And you say, yeah, if you want to. Okay, then you give it to then you can give it to the sheriff in the county which needs to be served then. So you can mail them the file stamp copy and say, I need this served on so and so, and then they'll get service back to you.
Will I have to pay for that then?
Yeah, it's about $35 or something like that. Any other questions about courts of record?
Yeah, do I need to even prepare for the other case in the inferior court?
I would prepare from a standpoint that you'd basically say, look, your best preparation is to file your counterclaim. Because once you file your counterclaim, then when you walk in, you say, Your Honor, I filed a counterclaim. And then you would open your court of record. Then you would say, Your Honor, the Superior Court of Record of the State of Iowa, which is a court of record, Your Honor, and it's the Superior Court, and I filed a counterclaim against the counter defendants. Challenge to jurisdiction of an inferior court can happen even after judgment. Now, technically, I wouldn't wait that long if I were you, but it can be done. So, but the point is that you want to have your suit in, filed, served, preferably before you even get to arraignment, which is why I have all these templates made out, so it's easy for people to just do and lay out and bam, So when you get there, you're opening your court of record right on top of them, and arraignment can't even happen, which is where they get you to basically agree to the jurisdiction of the inferior court. But a direct challenge to jurisdiction, though, comes over the top of that. So if there are any other questions about courts of record, let's open up and I'll go through the stuff about the 13th Amendment and why it's relevant to you every time you face an esquire sitting on the bench. And an esquire is obviously a foreign agent. Document number 26 is the pages from the statute laws of the Territory of Iowa, enacted at the first session of the Legislative Assembly of said territory, held at Burlington in 1838 to 39. And you scroll down here, and I just pulled out the specific pages that were interesting, which of course were the table of contents. So we got Declaration of Independence, Constitution of the United States, right? Okay, so let's go down. And of course, then you get to the Bill of Rights. 12th. What? 13th? The hell is this? Does this look like the abolition of slavery? Don't think so. If any citizen of the United States shall accept, claim, or receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain present, pension, office, or emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. That, my fellow people, is the original 13th Amendment. And it is blatantly in your face in the territorial laws of Iowa. It was ratified, it was printed, and it's real. What does this mean? What is this saying? Esquire is one title under a knight. From who? The filthy, illegitimate Rothschild cunt that's sitting on the British throne. Okay? Foreign agents. Somebody's an esquire, they cannot hold office in the United States. So you find an esquire on the bench, this is what you bring up. You get them out of there. Just get rid of them. You take 24 of your friends with you, and you stand up in the middle of court. You say, we accuse you of treason. Get out of here. Foreign agent. And it's also impersonating a public official because they don't have the capacity. No capacity, don't have it, right? So, important point. So that's for everybody. And then I gave the Articles of Confederation to prove that guess what? The 13th Amendment was in the original Articles of Confederation, where it states, Section 6, no state without the consent of Congress, the United States and Congress assembled shall send any emissary to or receive any emissary from or enter into any conference, agreement, alliance, or treaty with any king, prince, or state. Nor shall any person holding any office or profit or trust under the United States or any of them, except any present emolument, office, or title of any kind whatsoever from any king, prince, or foreign state, nor shall the United States and Congress assembled or any of them grant any title of nobility. Same basic thing. This is where it came from. It was in the Articles of Confederation. And then we came along and forced through the Constitution for the United States of America, thanks to Washington and Hamilton. They just forgot they just forgot this part. Well, the people later on said, no, you're not going to forget that part. That's where the 13th Amendment came from. Okay. So there's your Articles of Confederation connected with your 13th Amendment. And the last thing I have for the night is just other links of information to help you study American law. So the last document, number 28 document, it's a Word doc that has a bunch of links in it that you can copy and paste for finding foundational documents and other good things like various different papers and letters, the Federalist Papers, Anti-Federalist Papers, so on and so forth. And then these here are some really good sites. Archive.org is where you want to go to find a lot of old books don't have their copyright on them any longer. So you can find all these old treatises and stuff that I use off of archive.org. Edom Online is a fun one. That's just an aspect of etymology. So when you're curious about the original use of a word or where the thing came from, Edom Online is a fun thing to look up. You can learn a lot about origins of Latin and whatnot. The Online Library of Liberty, which is what that stands for, the OLL, has a lot of the foundational documents on it, which is fun. And then the last link here is Sovereign Education Defense Ministry, which I don't completely agree with everything that they do, but I'll give them this. They certainly have quite the library of free legal treatises that you can look up on there. So yeah, so there's the rest of the resources for you. And that's all I've got for tonight's class. So with that, thanks everybody for coming, and we'll see you next time.